I have stood on the edges of bridges I designed and felt the wind try to move me and held my ground. I have buried a marriage's worth of secrets to keep my family intact. I have endured things that would have broken smaller men and called the enduring gratitude. But nothing, not one moment in 68 years of living, prepared me for standing in a courtroom in Charlotte, North Carolina, listening to my wife of 31 years look a judge in the eye and say I was mentally ill. Nothing prepared me for my son standing beside her and nodding. And nothing in the history of this life I have built, prepared me for what happened next when the judge leaned forward, looked at the scar on my hand, and asked 4 words that changed everything. Are you ZAHA? Welcome back to your ultimate destination for gripping revenge stories, family betrayals, shocking betrayals, and emotional justice. Subscribe now and join a community and tell us where you're watching from. Turn on the notification bell for our next story. Are you ready to witness the ultimate payback? Let's get started. I am Mr. ZAHA, and I am 68 years old. Before I tell you what happened in that courtroom, I need to tell you who I was when I walked into it. Not who Florence said I was. Not the version she had been constructing, carefully, methodically, over the better part of 2 years, the way you construct a case. Brick by brick, witness by witness, piece by piece until the structure is complete enough to stand on its own without her needing to hold it up. I need to tell you who I actually was. The real man. The man the judge had not yet met when Florence opened her mouth and began. My full name is ZAHA. I have used the shortened form, Mr. ZAHA, for most of my professional life, the way some men shed the formal weight of their surnames in the daily business of being known. But the full name was there. It had always been there. And it mattered, on the day of the hearing, in a way I could not have predicted. I grew up in Raleigh, North Carolina, the son of a man who built furniture and a woman who taught high school mathematics for 30 years. We were not wealthy. We were not poor. We were the particular American middle, comfortable enough to be grateful, stretched enough to understand the value of what you had. My father believed in 2 things above all, the integrity of the thing you make and the keeping of your word. He used to say, standing in his workshop with sawdust on his forearms and a level in his hand, a crooked joint will hold in a warm room and betray you in a cold one. ZAHA. Make it straight from the beginning. I became a structural engineer. I spent 30 years designing things that held. Bridges, overpasses, load-bearing frameworks for buildings that would outlast me. I was good at my work in the way that people who are suited by temperament and training to what they do are good, not effortfully, but organically. The work fit me. It gave me the thing my father had given me through furniture, the satisfaction of something made true. I met Florence Carver in 1989 at a professional conference in Charlotte. She was there as an administrative coordinator for an architectural firm, and she was the most organized person I had ever encountered in a field that attracted organized people. She had a system for everything, for her business cards, for her schedule, for the notes she took during panels, for the way she arranged the world around her into something navigable and controlled. I found this attractive in a way I couldn't fully articulate at the time and can articulate very precisely now. She made chaos orderly, and I had spent my professional life combating the chaos that gravity and load and time impose on structure. We were, at the level of fundamental orientation, speaking the same language. We married in 1991. We had our son, Polska, in 1994. We built a life in Charlotte that was, by most visible measurements, a successful one. A house in a good neighborhood. A son who grew up well-mannered and educated, who went to NC State for business and graduated with honors, and built a career in corporate finance that made me proud in the way that fathers are proud of sons who exceed their own beginnings. Florence managed the household with the same systematic competence she brought to everything, and I provided for it with the same thoroughness I brought to my structures, and for 20-some years the arrangement functioned. What I did not know, or what I knew partially, in the way you know that a load is shifting before the instruments confirm it, a sense in the body before the data arrives, was that Florence had, somewhere in the 2nd decade of our marriage, made a decision about what she wanted that did not include me in its full form. I cannot tell you precisely when it began. Marriages end the way bridges fail, not in the visible catastrophic moment, but in the accumulation of invisible stresses that precede it. A hairline fracture that widens with each load cycle. A joint that holds in the warm room and betrays in the cold one. I had seen, in the last several years, things that I had filed in the back drawer of my attention rather than bringing them forward to examine. Florence's increasing financial independence, her gradual withdrawal from shared decisions, the way she answered my questions with a precision that was technically complete but emotionally absent. The way our conversations had the quality of transactions rather than the quality of two people who had built a life together. And I had seen, or rather, I had not allowed myself to fully see, the change in Polska. My son was 29 years old, tall, with his mother's precision and what I had believed was my work ethic. He had moved back to Charlotte 2 years ago after a stint in Atlanta, and he had moved back into proximity not with me, but with Florence, calling her daily, spending Sunday evenings at the house, developing a closeness with his mother that I had, at first, regarded as the natural affection of a son for his mother. It was only later, when the closeness developed an edge that was directed at me, that I began to understand it differently. Florence had been telling Polska things. Not lies, exactly, or not exclusively lies, but a version, a selective accounting of our marriage from her perspective, offered to our son over months and years of Sunday evenings and daily phone calls, received by a young man who loved his mother and who had, in the receiving of it, gradually shifted his orientation toward her and away from me. I did not know the full extent of this until the morning I found the papers. The papers arrived by certified mail on a Tuesday in October. I was in my home office. I had maintained a consulting practice since my retirement from the firm, smaller scale but still active, and the envelope sat on the kitchen counter when I came down for coffee with the particular authority of certified mail, the kind that requires a signature and carries weight. Florence was already gone for the day. She had, in the last 18 months, developed a schedule of activities and appointments that kept her out of the house most mornings, which I had accommodated without interrogation. I opened the envelope. Divorce proceedings. Initiated by Florence. Citing irreconcilable differences and this is the part that stopped my hand on the page, citing, as a supporting concern, what the filing described as the respondent's increasingly erratic and unstable behavior, including episodes of confusion, aggression, and apparent cognitive decline, which required, Florence's attorney argued, expedited consideration given concerns about the respondent's capacity to manage his own affairs. I read those words 3 times. Erratic, unstable, confusion, aggression, cognitive decline. I sat down at my kitchen table with the papers in my hands, and I thought about the engineering precision with which Florence organized things. I thought about how long this document must have been in preparation. I thought about the Sunday evenings and the daily phone calls and the gradual reorientation of my son toward his mother. And I understood, with the cold clarity of a man reading a structural report that reveals what he had been walking over without knowing, that this had been a construction project. Florence, who organized everything, had been organizing this. The hearing was scheduled for 6 weeks from the date of the filing. I called an attorney. Her name was Patricia Aldrich, a woman in her 50s with a reputation for thoroughness that had been recommended to me by my friend Howard. Patricia read the filing and looked at me across her desk and said, carefully and without drama, "Mr. ZAHA, I want to be straightforward with you. The mental capacity language in this filing is serious. It's not a standard irreconcilable differences petition. They're making an argument that is designed, if successful, to give Florence significant control over the outcome, including asset division and potentially your independent decision-making. We need to prepare thoroughly." "What does thoroughly require?" I asked. "Documentation," she said. "Medical records. Testimony from people who know you. Character witnesses. Evidence that directly contradicts the characterization they're building." She paused. "And we need to understand where that characterization came from. Who gave them this language? Who has been saying these things about you?" I thought about Polska, about Sunday evenings and daily phone calls. "I think I know," I said. The 6 weeks of preparation were among the most disorienting of my life. Not because I doubted myself. I did not doubt myself. I knew with the same certainty, I knew structural calculations that I was not what Florence's filing said I was. But because the experience of being characterized, of having a false version of yourself assembled in official language and submitted to a court, produces a particular kind of existential vertigo. You look in the mirror and you see yourself clearly, and then you read the document, and the document is describing someone you don't recognize, and the fact that the document exists and will be read by a judge gives it a weight that your own clear-eyed self-knowledge cannot fully counteract. Patricia was excellent. She gathered what needed gathering. She prepared what needed preparing. She told me, the evening before the hearing, be steady tomorrow. Be exactly who you are. Don't perform calm, be calm. The best thing you can do in that room is be the man they're saying you're not. I arrived at the courthouse on a November morning in Charlotte when the sky was the flat gray of late autumn and the streets were wet from overnight rain. I wore my good suit, charcoal, the one I had worn to professional presentations and board meetings and the funeral of my best friend 12 years ago. I wore it because I believed in the integrity of presentation. My father's voice, make it straight from the beginning. Patricia was beside me. We took our seats at the respondents' table. Florence came in with her attorney and sat across the aisle. She did not look at me. Polska came in behind her. He sat beside his mother. He did not look at me either. I sat at that table and I looked at my son, willing him to meet my eyes, and he looked at the table in front of him, and something happened in my chest that was not quite grief and not quite anger. Something older than both of those. The thing a father feels when he understands, fully, for the first time, that the child he has raised has been turned toward him like a tool. The judge entered. And everything that happened next, everything, I was not prepared for. Before we go any further, tell me in the comments, what do you think Florence has been telling Polska all this time? What would you have done in Mr. ZAHA's position? The judge's name was the Honorable Sandra Edward. I note her name because it matters, because she is central to what happens in this story in a way that I could not have anticipated when she walked into that courtroom and the bailiff called order and everyone rose. She was in her early 60s, I estimated. A black woman with close-cropped silver hair and the particular bearing of someone who has presided over human difficulty for long enough that nothing surprises her, but everything still receives her full attention. She moved with the economy of a person who had learned not to waste motion. She sat. She arranged the materials before her. She looked up at the room. Her eyes moved across both tables with the systematic attention of someone conducting an assessment. Florence's attorney went first. His name was Barrett Holloway, a man in his late 40s with an expensive suit and the practiced confidence of someone who had delivered this kind of opening many times. He outlined the petition, irreconcilable differences, 31 years of marriage, the asset question, and then the capacity language, carefully, methodically, citing the filing, citing what he called documented concerns about my mental and cognitive state. I watched Judge Edward as he spoke. She was listening with her full attention, her expression neutral in the way of someone who has learned that premature conclusions are a form of inefficiency. She made notes. She did not react to the capacity language with the alarm or the credence that Holloway's delivery seemed designed to produce. Then Holloway called Florence to speak. Florence stood. She was 63 years old and she was, as she had always been, immaculately presented. She wore a dark blue suit and her hair was precise, and she stood at the front of the courtroom with the composure of a woman who had organized herself for this moment the way she organized everything, completely, with every contingency considered. She spoke for 12 minutes. I will not recount all of it. I will tell you what it felt like, because the factual content is less important than the experience of sitting 3 feet away from someone you spent 31 years building a life with and hearing her describe you as a stranger. No. Worse than a stranger. As a man diminished. As a man whose hold on his own reality had become uncertain. She spoke about incidents that had not occurred the way she described them. She spoke about episodes of confusion that had been, in their actual form, ordinary moments of disagreement that she was now recasting through a lens of pathology. She spoke about concerns she claimed to have raised with me that she had not raised. She spoke with the careful, sorrowful voice of a woman who had tried and endured and was now, reluctantly, seeking the protection of the court. She was convincing. I will give her that with the honesty it deserves. Florence had always been convincing when she organized her presentation. She had organized this one over the course of what I now understood had been years. And then she said it. Your Honor, my husband is mentally ill. Her voice, steady, clear. The voice of a woman stating a fact. He has been deteriorating for several years, and refusing to acknowledge it or seek help. He is not capable of managing his own affairs, and I am genuinely concerned for his well-being and for the well-being of the assets we've spent our lives building. Mentally ill. Said simply. Said clearly. Sat in a room full of people, including a judge and a bailiff and a court reporter and my attorney and my son, who was sitting 6 feet away from me and who did not move and did not object and did not look at me. I kept my hands flat on the table. Patricia had told me, be steady. Be exactly who you are. I was steady. But I want to be honest about what steady cost in that moment. What it required in terms of the pure engineering of self-control, holding a load that wanted very much to move, keeping the structure intact when everything in me wanted to stand up and say, that is not true. I am sitting here. I am here. I built things. I have held things. I am not what you were saying I am. I held. Then Judge Edward looked at the petitioner's side of the room and said, is there additional testimony? Florence's attorney said yes and called Polska. My son stood. He was 29 years old, and he was wearing a suit I recognized, the charcoal one I had given him 3 Christmases ago, a gift he had seemed genuinely pleased by. He walked to the front of the room with the bearing of a young man who had prepared for this, who had been told what to say and when to say it, who had crossed, at some point between Sunday evenings and daily phone calls, from his father's son to his mother's witness. He spoke for 6 minutes. I counted them. He corroborated Florence's account. He spoke about incidents, the same recasting, the same pathologizing of ordinary behavior through the lens his mother had provided. He spoke with the particular earnestness of a young man who believed what he was saying, which was the most painful part. He was not cynical about it. He was not performing. He had been given a version of his father and he had accepted it, and now he was offering it to the court with all the conviction of a man who believes he is telling the truth. He finished. He sat down. He still did not look at me. The room was quiet for a moment, and I want to tell you precisely what happened in me in that moment, because it is important and because I have not spoken of it fully to anyone. It was not simply hurt, though hurt was there, a hurt so specific and so located that I could have pointed to the square inch of my chest where it lived. It was something more complex, a disorientation, the particular disorientation of a man who has always known who he was, structurally, fundamentally, in his bones and his work and his history, and who is now watching 2 people he made his life with tell a room full of strangers a different story. 2 people who know him. 2 people who were there for the original events. And yet the version they are presenting bears so little resemblance to anything he recognizes that he is, briefly, gaspingly, unsure whether the floor is still in the same place. I pressed my hands flat on the table. Patricia put her hand briefly on my arm. A steadying touch. A message. Judge Edward made several notes. Then she looked up, and her eyes moved across the petitioner's side with their systematic attention, and then they moved to me. She looked at me. Not the way people look at someone in a proceeding, assessingly, professionally, at a managed distance. She looked at me the way a person looks when something has snagged their attention, when a detail has pulled focus in a way that is not immediately explicable. She was looking at my hands, flat on the table, and specifically, I tracked her gaze and understood in real time what she was seeing, at the scar on my right hand. The scar was not dramatic. It ran from the base of my index finger to the outside edge of my wrist, the residue of a significant laceration from 22 years ago, a workplace accident on a bridge site, a piece of steel cable under tension that had released without warning. The scar was pale and slightly raised and shaped in a way that was distinctive, a slight curve at its base that engineers who knew the story said looked, ironically, like a stress curve diagram. Judge Edward was looking at it. She was leaning forward. And then she said, in a voice that was neither loud nor soft, but carried with complete clarity across every surface of that courtroom, excuse me, are you ZAHA Loskai? The room went silent. Not the managed silence of court procedure. A different silence. The silence of a room in which something has shifted so completely that everyone present has felt the shift before understanding its cause. I looked at the judge. Yes, Your Honor, I said. That is my full name. She looked at me for a long moment. Then she looked at the scar again. Then she set down her pen and sat back and said, to the room at large, in the tone of someone who has just arrived at an understanding that changes the entire geometry of what they are looking at, we're going to take a 15-minute recess. She stood. The bailiff called order. Everyone rose. And Florence, across the aisle, looked at her attorney, and what I saw in her face for the first time that morning was something she had not shown since she walked in: uncertainty. The judge just leaned forward and asked that question. The courtroom went silent. Tell me in the comments. What do you think she knows? What do you think is about to happen? The 15-minute recess became 30. I know this because Patricia and I stood in the corridor outside the courtroom, and I watched the minutes on the wall clock move with the deliberate patience of a man who has learned that time does not accommodate urgency. Patricia was on her phone briefly, then off it, then looking at me with an expression that had shifted from the prepared, professional composure she'd maintained through the morning's testimony to something more alert, more interested. Do you know her? She asked. I don't know, I said. I don't think so. Not socially. But the way she said the name. She recognized something, Patricia said. The scar. She saw the scar, and then she said your full name. ZAHA. Not many people know that name unless. She paused. What does the scar mean to you? I told her about the bridge site accident. About the cable. About the year it happened and the circumstances. Patricia listened carefully. What year? 2002, I said. March of 2002. The Linwood Overpass Project. Outside of Greensboro. Patricia looked at me steadily. Something was assembling in her expression. Stay here, she said. Let me make one call. She walked down the corridor, phone to her ear. I stood by the window and looked out at the wet Charlotte street and the flat November sky, and I thought about Judge Edwards' face. About the way she had leaned forward. About the quality of recognition in her eyes when she said my name. Not the professional recognition of a judge confirming a party's identity for the record, but something older. Something personal. ZAHA. My full name. And used in professional contexts for 2 decades. The name on my engineering license. The name on the original documentation for every bridge project I had ever worked on. The name on the Linwood Overpass records. The name on the incident report from March of 2002, when a cable had released and taken a piece of my hand with it. Patricia came back. Her expression had arrived at something definite. I called my paralegal, she said. I asked her to look up Judge Sandra Edwards' biography. She paused. Before she was on the bench, she was a civil litigation attorney. She specialized in construction and infrastructure liability cases. Another pause. Between 1999 and 2004, she worked for the firm that represented the Linwood Overpass Project's primary contractor. I looked at my scar. She was there, I said. Not a question. Not at the accident. But the litigation after it. The liability proceedings that followed your injury. Her firm was involved. She would have seen the documentation. She would have seen the incident reports, the injury records, the witness testimony. She would have seen your name. Patricia looked at me. She would have seen photographs of the scar, because that scar was the central documented evidence of the severity of your injury and the resulting liability claim. I stood in that corridor with this information and I assembled it with the same methodical care I brought to structural analysis. Sandra Edward had known my name, my full name, ZAHA, from documentation that was 22 years old. She had seen my scar in a photograph in a legal file 2 decades ago. She had looked at my hands in the courtroom and seen the scar and made a connection that had pulled her out of the professional remove of the proceeding. She knew who I was. Not Florence's version. Not Polska's corroborated testimony. The documented, litigated, officially recorded version. A man who had been on a bridge site in 2002. A man whose injury was on record. A man whose capacity, whose presence, whose physical reality had been established in legal documentation 2 decades before this morning. What does this mean? I asked. It means, Patricia said carefully, that Judge Edward has information about you that predates everything Florence's attorney has presented. Information that is documented, impartial, and legally established. She paused. It means that when she looks at you, she is not seeing a stranger whose mental capacity is being contested. She is seeing a man whose history she has encountered through legitimate documentation. A man who was present, functional, and identifiable 22 years ago. She met my eyes. It does not automatically win anything, but it changes what the judge brings to the rest of this proceeding. She knows the name. She knows the scar. She has a reference point that has nothing to do with what Florence or Polska said this morning. We went back into the courtroom when the recess ended. Judge Edward resumed the bench. Her expression was composed in the way of someone who has processed something and is now prepared to proceed with the additional information integrated. She looked at me once, briefly, when she sat down. Then she looked at the room. I want to hear from the respondent's side, she said. Ms. Aldridge, proceed. Patricia stood. She was excellent, methodical, thorough, presenting the counter-narrative not as refutation but as documentation. Medical records from my physician of 12 years, Dr. Harmon, who had submitted a written statement confirming that I was in good cognitive and psychological health, with no clinical findings consistent with the conditions described in the filing. Letters from 3 professional colleagues, engineers I had worked with across my career, attesting to my current functioning and professional competence. Bank records demonstrating my continued, orderly management of my personal finances. The consulting contracts that showed I was still engaged in productive, technically demanding work. Florence's attorney objected, periodically, with the particular energy of a man who had built a case carefully and is watching the foundation being examined more closely than he anticipated. Judge Edward noted the objections and overruled most of them. Then Patricia called me. I took the stand. I had prepared for this, had rehearsed with Patricia, had organized what I wanted to say with the same care I brought to engineering presentations, knowing that structure and clarity and the absence of defensiveness were my strongest tools. I sat in the witness stand and I looked at the judge, and I did not look at Florence or at Polska. I told the truth. Not the performed truth of a man trying to appear well, the actual truth. I talked about my work, about the projects I had consulted on in the past 2 years, about the clients I had served, about the morning walks and the cooking and the reading and the ordinary, functional texture of my days. I talked about the incidents Florence had described, and I gave the actual version of each one, not with anger, not with the heat of a man defending himself from insult, but with the calm specificity of someone who was there and knows what occurred. Patricia asked about the relationship with Polska. I paused on that question, organized myself. Polska is my son, I said. He is 29 years old, and I love him. And I believe that he has been told things about me, over a significant period of time, that are not accurate. And I believe that he believes them, because he loves his mother and because he trusts her. I am not angry at my son. I paused. I am heartbroken that he is in that seat. But I am not angry. The courtroom was quiet. Judge Edward was watching me with the full, specific attention she had given Florence's testimony, but the quality of it was different. Where her attention to Florence had been the systematic attention of a judge processing claims, her attention to me had something additional in it. The particular attention of a person for whom the subject in front of them has context, has history, has existence that predates this room. Florence's attorney cross-examined me for 20 minutes. He pushed on the incidents. He pushed on my relationships. He tried, with professional skill, to produce the erratic, unstable version of me that the filing described. I answered every question with the same level, documented steadiness. I did not rise to any provocation. I was, as my attorney had asked me to be, exactly who I was. When it was over and I had returned to my seat, Patricia leaned toward me and said quietly, "You were exactly right." But it was not my testimony that mattered most. It was what happened when Judge Edward called a second brief recess and then returned to the bench with a document in her hand. A document she had requested during the first recess. A document that had been retrieved from the court's electronic record system during the 30 minutes that the recess had extended while Patricia and I stood in the corridor. The incident report from the Linwood Overpass Project. March 14, 2002. Describing the cable accident. Describing the injury. Attaching the medical documentation of the laceration and the resulting scar. Filed under the full name, ZAHA. She set it on the bench in front of her, and she looked up at the room. And Florence, across the aisle, looked at that document. She could see it from her seat, see its header, understand what it was, and for the first time since the proceeding began, the systematic composure that had organized her through the morning developed a visible fracture. Everything is about to change. Tell me in the comments, what do you think Judge Okafor is about to say? What should happen to Florence's case now? I want to hear every thought. Judge Edward did not speak immediately. This is a thing I have noticed about people of genuine authority. They do not fill silence reflexively. They hold it. They use it. A silence deployed by a person in full command of a room is not an absence of communication. It is communication in a different form. Judge Okafor held the silence of that courtroom for approximately 30 seconds, which is a very long time in a room full of people waiting for something. And in those 30 seconds I watched Florence's composure continue its fracture, and I watched Polska, for the first time since he had taken his seat beside his mother, look up from the table in front of him. He looked at me. For the first time all morning, my son looked at me. And what I saw in his face, across the width of that courtroom aisle, across the distance that had been growing between us for 2 years of Sunday evenings and daily phone calls, was not the prepared witness. Not the young man who had stood at the front of the room and corroborated his mother's account with the conviction of someone who believes what he is saying. What I saw was a young man who was noticing something, who was watching the judge hold a document that he had not known existed, who was doing, in real time, the calculation that I had done in the corridor during recess. His expression was doing something I recognized because I had seen it before, on his face when he was a child, and realized that a belief he held with certainty was wrong. The particular expression of a person in the moment before they revise. Judge Edwards set down the document. "I am going to speak directly to both parties," she said. Her voice was measured and carried without effort across the room. "And then I am going to ask some questions that I expect to be answered with equal directness." She looked at Florence's table. "The petition before this court includes a serious allegation," she said. "The characterization of the respondent as mentally compromised and potentially lacking capacity to manage his own affairs is not a routine element of a divorce petition. It is a significant legal claim that, if accepted by this court, would have substantial consequences for the respondent's rights and autonomy." She paused. "I take such allegations seriously. I also subject them to serious scrutiny." She looked at the document on her bench, then at me. "I have before me an incident report and associated medical documentation from 2002, 22 years ago, that establishes the respondent's identity, his presence and functioning at a professional engineering site, and the origin of the scar visible on his right hand." She paused. "I was professionally adjacent to this documentation during my time in civil litigation, which is why I recognized both the name and the scar when I encountered them this morning." She looked at the room. "I want to be transparent about that recognition and its source." Florence's attorney was on his feet. "Your Honor, I would submit that any prior professional proximity to Mr. Holloway," Judge Edwards said, not raising her voice. "I have not asked for your submission. I will invite it when I am ready for it. Sit down, please." He sat. "The documentation I retrieved is not the basis for my ruling," the judge continued. "It is, however, context. It establishes that the respondent has a documented, verifiable history that predates and exists independent of the characterizations in this petition. A history that includes professional functioning at a high level, engagement with complex technical work, and a physical identity, that scar, that connects him to a specific, documented moment in time." She looked at me steadily. "Mr. Losky, I want to ask you several questions, and I want the answers on the record." "Of course, Your Honor." "How long have you been practicing structural engineering in a professional capacity?" 31 years in full practice," I said. "In the past 8 years as an independent consultant." "Have you had any clinical diagnosis of a mental health condition, cognitive disorder, or any condition affecting your capacity to manage your affairs?" "No, Your Honor. My physician's statement, which has been submitted to this court, confirms no such diagnosis." The incidents described in the petition, the episodes of alleged confusion, aggression, and erratic behavior, did they occur as described? "No, Your Honor. In each case I can provide the actual account of what occurred. My attorney has presented documentation that contradicts the characterization in the petition." Judge Edward nodded. Then she looked at Florence's table. "At Florence." "Mrs. Losky," she said, "I have some questions for you as well." Florence's attorney started to stand. Judge Edward held up one hand, and he sat back down. "The language in this petition regarding your husband's mental capacity, who provided that characterization? Was it a clinical professional? A licensed psychologist or psychiatrist?" Florence looked at her attorney briefly, then back at the judge. "Based on my observations," she said, "and the observations of family members." "Was it based on a clinical assessment by a licensed professional?" the judge asked again, precisely. "Not a formal assessment, no, but—" "Thank you," said Judge Edward. "And the episodes described, were any of them reported to law enforcement, to medical professionals, or to any authority external to the family at the time they allegedly occurred?" A pause. "No, Your Honor." "Were any of them documented contemporaneously, written down, reported to a doctor, recorded in any form, at the time they occurred?" Florence's hands, on the table in front of her, were still. No. The courtroom was very quiet. Judge Edward looked at Polska, my son, who had been sitting with the expression of a man in rapid internal revision since the judge had produced the document, met her eyes with the startled attentiveness of someone who had not expected to be addressed directly. "Young man," she said, not unkindly, "you testified this morning about your father's behavior. The incidents you described, did you witness them personally, or were they related to you by your mother?" The silence in the courtroom deepened. Polska's jaw moved. He looked at his mother. He looked at me. He looked at the judge. "Some of them," he said, slowly, carefully. I could hear him choosing, in real time, between the prepared version and the honest one. "Some of them were things my mother told me about." "How many of the incidents you testified to did you personally witness?" Another pause. "Longer." "2," he said. "Maybe 2. "And the others?" "They were. My mother described them to me." Judge Edward wrote something down. The court reporter's fingers moved. Florence's attorney sat with the particular stillness of a man who is watching a structure he built begin to fail under examination and is calculating which elements can still be salvaged. Then Judge Edward did something I did not expect. She set down her pen and she looked at the room, at all of us, both tables, the whole geometry of the assembled family conflict, and she said something that I have thought about every day since. "I want to say something that goes beyond the immediate legal question before this court," she said. "In 30 years of legal practice and 11 years on this bench, I have seen many things characterized as symptoms of instability that were, in fact, symptoms of a marriage in pain. I have seen the language of mental health weaponized against people who did not deserve it and cannot adequately defend themselves against it, because the nature of the allegation is that denial confirms the diagnosis." She paused. "This court takes capacity allegations seriously precisely because they carry that risk. And when I see a petition that uses that language without clinical support, without contemporaneous documentation, and with testimony that is, by the witness's own admission, substantially secondhand, I am obligated to say so clearly." She looked at Florence. "Mrs. Losky, I am not ruling today on the divorce petition as a whole. There are legitimate questions of asset division and the details of the marriage dissolution that this court will address in due process. But I am ruling, clearly and for the record, that the capacity language in this petition is unsupported by the evidence presented. The respondent has demonstrated, through documentation and testimony, that he is fully capable of managing his own affairs." She paused. "The capacity claims are dismissed." Florence's attorney opened his mouth. "Mr. Holloway," Judge Edwards said, "I have ruled." He closed it. I sat at the respondent's table and I breathed. Patricia put her hand briefly on my arm, the same steadying touch as before, but different now. Not steadying against an incoming wave, acknowledging the wave that had passed. Across the aisle, Florence was looking at the table in front of her. Her composure was intact in its external form, but the thing behind it, the certainty, the organized precision of a woman whose plan was proceeding as organized, was not there anymore. She had built a structure and the judge had examined it and found it unsupported, and Florence, who understood structure, understood what that meant. But it was Polska I was watching. My son had turned in his chair, not toward his mother, away from her, slightly, the almost imperceptible reorientation of a young man who had just heard a judge say, with the authority of the bench and the specificity of 11 years of legal experience, that the testimony he had offered was substantially built on what he had been told rather than what he had witnessed. Who had heard, for the first time, a voice external to his mother's account examine that account and find it insufficient. He was looking at his hands. He was 29 years old, and he was sitting in a courtroom where his father had just been publicly cleared of a characterization his son had helped construct, and he was looking at his hands with the expression of a person doing a reckoning. I did not look away from him. I let him feel me looking, not with anger. I had said from the stand that I was not angry at my son, and that was true, and I held it as true in this moment because it was the most important thing I could offer him right now. Not anger, not accusation, just presence. A father, present, across the aisle. After a moment, Polska looked up. He met my eyes, and I held his gaze, across the distance of 2 years and a courtroom aisle, and everything that had been built between us without my knowledge, and I did not look away. The judge ruled. The capacity claims are dismissed. But what about Polska? What about Florence? Tell me in the comments. What do you think happens when this family leaves that courtroom? What should Mr. ZAHA do next? The proceedings adjourned at 2:15 in the afternoon. The divorce itself, the asset division, the formal dissolution of the 31-year marriage, would continue in subsequent proceedings. Judge Okafor had been clear about that. There were legitimate financial questions to be addressed, and they would be, in due process and in due time. Patricia and I had discussed this in preparation, and we were prepared for the long form of it, the months of documentation and negotiation that the actual dissolution would require. But the capacity claims were gone. That was the thing that mattered most. Not because the assets were unimportant. They were not. They represented 31 years of accumulated work and provision, but because the capacity claim had been the architecture of Florence's strategy. It had been designed to position me as someone who could not adequately represent himself, whose version of events was inherently unreliable, whose objections to the terms of the dissolution could be discounted on the grounds of his own instability. Without it, the case returned to its ordinary geometry. Two people ending a marriage, both of them capable, both of them withstanding, both of them required to negotiate from a position of basic equality. Florence had lost her structural advantage. I walked out of the courthouse with Patricia into the flat November afternoon. Patricia said several things that I absorbed without fully processing, the way you absorb technical information immediately after a high-load event, present for the content, requiring time to integrate it. She said the next steps, the timeline, what she needed from me in the coming weeks. I said yes to each element, and I meant it, and I would follow through. But the part of my attention that was not occupied with the procedural aftermath was occupied with something else. With the image of Polska's face in the courtroom when he had looked at his hands. I was at my car when I heard footsteps behind me on the courthouse steps. I turned. Polska was there. He was still in the charcoal suit, my gift, 3 Christmases ago, and he had clearly left his mother's group in the lobby, because he was alone, and the fact of his aloneness told me something about the cost of that choice. He stopped at the bottom of the steps and looked at me with the expression of a young man who has rehearsed nothing, who is doing this without preparation, without the organized support of his mother's voice in his ear. Just himself. Just my son. We looked at each other across the parking lot for a moment. Dad, he said. One word. The word he had not said all morning. Not from the witness stand. Not in the courtroom. Not in the years of drift that had preceded it. Dad. Not a performance. Not a prepared witness's address. Just the word that meant me, coming from the person who had the most right to say it. I walked toward him. We were not in the movies. I did not open my arms, and he did not run. We were a 68-year-old man and a 29-year-old man standing in a courthouse parking lot in Charlotte on a November afternoon, and we were doing what men of our generation and our habits do when confronted with the need for repair. We occupied the same space, and we looked at each other, and we let the silence do the work that neither of us had the ready language for. I didn't know about the document, he said. The scar. The bridge site. I didn't, he stopped. There are things I didn't know. There are things you weren't told, I said. He looked at me for a moment. Then, she said, she told me things, over the last 2 years, about you. About things you'd done and said. About the way you'd been behaving. He paused. I believed her. Because she's my mother, and because she was, he stopped again. She was convincing. She is always convincing, I said. She organized herself for 31 years. I should have come to you, he said. I should have, before I agreed to anything, before I agreed to come to court. I should have come to you and asked you directly. Yes, I said. No qualification. No gentling of it. He deserved the honesty. You should have. He flinched slightly at the directness of it. Then he nodded. I know. But you're here now, I said. That took something. He looked at his shoes briefly. She's going to be angry, he said. That I talked to you. Probably, I said. That's something you'll need to navigate. I paused. I can't do that for you, Polska. Your relationship with your mother is yours. What happened in that courtroom is something she will need to reckon with, and how she reckons with it is between her and her own conscience, and, eventually, between her and the proceedings that are still coming. I looked at my son steadily. But your relationship with me, that is something I would very much like to rebuild, if you want that. He looked up. I want that, he said. The simplest version of it. The most honest. Then that's where we start, I said. From here. Not from before. From here. He put out his hand. A handshake, formal, and I knew exactly what the formality meant. It meant he understood the distance that needed to be crossed and was acknowledging it rather than pretending it wasn't there. It meant he was starting over with the full awareness of what starting over required. I shook his hand, held it a moment longer than the shake required. Let go. Call me this week, I said. I will, he said. He went back up the courthouse steps. I watched him go, and I thought about Polska at 9 years old, sitting beside me on a Saturday morning while I explained to him the principles of load and support with building blocks on our living room floor. About how he had asked, with the precision that came from Florence and the curiosity that came from me, "But what happens if the load gets too heavy, Dad?" And I had said, "Then you redistribute it. You don't let one element carry more than it was designed for. You share the load." He had been carrying a load that was not designed for him. He was setting it down. That would have to be enough for now. 3 weeks later, I called Howard. Howard Briggs, 71, my friend of 12 years and the man whose recommendation of Patricia Aldridge had altered the outcome of a courthouse morning. Howard, who had been through his own fires and come out with the particular wisdom of a man who has been tested and not broken. I called him on a Saturday morning and I told him the whole thing. The filing, the preparation, the courtroom, the testimony, the scar, the judge's question, the parking lot conversation with Polska. Howard listened the way he always listened, with complete attention and without interruption, which was a gift he gave freely and which I valued more than I had always said. When I finished, he was quiet for a moment. Then he said, "ZAHA, the scar. Yes. You got that scar doing your job, doing the thing you were built to do. And 22 years later, it's the thing that told the truth about you in a room where the truth needed telling." I thought about that. My father used to say, I said, that the crooked joint will hold in a warm room and betray you in a cold one. Make it straight from the beginning. Florence's case was a crooked joint, Howard said. Yes, I said. It was. And it held until it got cold enough. Until the judge leaned forward, I said. Until she recognized the name. Howard was quiet for a moment. Then, what do you need now? Practically, what do you need? I thought about the question. Thought about it the way I had learned, over the past months, to think about it. Not with the reflex of a man who needs nothing and never asks, but with the honest attention of a man who has been through something and knows the difference between pride and wisdom. I need a good Saturday, I said. I need to sit somewhere and have coffee and not think about proceedings or documentation or asset division for a few hours. Come over, Howard said. I'll put the coffee on. I drove to Howard's house on a Saturday morning when Charlotte was doing its November best, gray and still, and the last of the leaves coming down from the trees along his street in the slow, purposeful way that ending seasons release things. I sat at Howard's kitchen table and drank his coffee, and we talked about everything and nothing, the way two old men talk when they have known each other long enough to have exhausted performance and arrived at simple company. At some point, Howard said, "The boy, Polska, you think he'll come around?" "He already started," I said. The parking lot was a start. That's something. It's everything, Howard. It's the whole thing. We were quiet for a while. I thought about the courtroom. About Florence's voice saying mentally ill with the organizational precision she brought to everything. About Polska's face on the witness stand. About the silence that fell when the judge leaned forward and asked her question. About the document on the bench. About the scar on my hand. A scar from 22 years ago. A piece of steel cable under tension, released without warning, taking something and leaving something in exchange. The way injuries always work, the thing they take and the thing they leave, and you living with both. I had always thought of the scar as the residue of a cost, the record of something that had been taken. I had not thought of it as something it would ever give back. But there in the courtroom, under the eyes of a judge who had encountered me through documentation before she encountered me in person, the scar had spoken. It had said, "This man was here. This man is real. This man has a history that exists independent of what anyone in this room says about him today." The truth had always been in the room. It just needed someone to look at the right hand and ask the right question. I am Mr. ZAHA. I am ZAHA Loskai. I am 68 years old. I have built bridges that carry thousands of people across distances they couldn't cross alone. And I have learned, in a courtroom, in a parking lot, at Howard's kitchen table, that the most important bridge is the one you build back toward the people you love when the load between you has been distributed incorrectly and somebody finally redistributes it. Polska called me that Wednesday. We talked for 40 minutes. About nothing important. About everything important. About the Saturday mornings with building blocks on the living room floor. About a bridge outside Asheville that I told him I wanted to show him sometime. If he ever had a Saturday free. He said he'd make a Saturday free. He did. My father used to say, make it straight from the beginning. Sometimes you can't. Sometimes the joint is crooked before you know to straighten it, and you spend years discovering the crookedness in the cold. But if you find it, if something, a judge leaning forward, a question asked at exactly the right moment, pulls the truth into the light, then you have the chance to do what you couldn't do at the beginning. You make it straight now. Now is enough. Now is everything. A man is not what others say he is in their worst moments. He is what he has built, what he has held, and what he chooses to do when the truth is finally given the floor. ZAHA Sky. If this story stayed with you, if Mr. ZAHA's voice, the scar, the judge's question, or that parking lot moment with Polska moved something in you, please leave a comment below right now. Tell me which moment made you stop breathing. Tell me if you've ever been called something you weren't and had to find a way to prove it. Tell me what this story meant to you. These comments are the reason these stories exist. Every single one of them keeps this going. Thank you so much for watching my story all the way to the end. Your support means everything. Don't forget to subscribe to my channel and drop a comment below. I'd love to hear your thoughts.